the government.
That still gets back to why is the government, I guess I'm just stuck on this. You said this is across all sorts of government programs, obviously agree. Why is the government then taking a position that you say will thwart the implementation operations of all these government programs? I'm just not seeing that, and because they're on the other side, it casts doubt on your assertion that all these programs are going to be, obviously we're going to ask the government this too. But.
I was going to suggest that you ask Dr. Joshi that very question. And it is to some extent better directed to him. All I can say is that, what's driving their brief, as far as I read it, is this reconceptualization of the long common law history and the idea that, in fact, what this court and others have been doing, but never saying it, is applying some sort of derivative privilege born in the pages of the restatement, and urged, by the way, on this court in Campbell-Ewald, and the court didn't take the bait, urged on the Ninth Circuit in Childs, the 2022 decision, that court didn't take the bait, repeated here in the CVSG brief in CACI from a few years ago. No one has embraced this thing, and it's not new. Well, it's somewhat new, it's 8 years old. But before that, the government was consistently on the side of its contractors. And again, beyond that, I just have to leave it to the government. If the calculation is about the burden imposed on contractors, the government doesn't really have a perspective on life as a private litigant. They don't have to hire outside counsel.
But couldn't you negotiate for that in your contract with the government, that they cover your litigation expenses?
No, I wish we could. So the Anti-Deficiency Act, of course, prevents us from having an open-ended indemnification. FAR 31.205 prevents any number of litigation costs from being built in. This is a fixed price contract, as all of these are.
Well, couldn't you fix that into the price of the contract?
No, because the FARs exclude. Very fair question. The FARs exclude these litigation expenses, and if we were to put them in as sort of like overhead or something, that would be a false claim and would expose us to a suit under the False Claims Act. So there again, although it is a real problem for GEO